Hello, everybody. Good morning, or good afternoon, rather, and welcome to the University of Toledo College of Law 51st Annual Fornoff Competition. I am Wesley Henkel, a 3L student here at the law school, and alongside my co-coordinator, Mr. John Robinson, we have led the competition this year and organized to get us to this day. Thank you for everybody for being here. We're glad to see this be back in person. This will be my first in-person Fornoff competition as a third-year student, so if that tells you anything. This is a long-standing tradition here at the College of Law. It's very illustrious. It's quite a storied history, so we're very proud to be here today with our Final Four competitors and our judges. I have a few announcements to make before we start. Professor Fenton's torts class, for those of you that are in that, she has agreed that the class will start at 1:40 p.m., so you do not have to leave early. You can stay for the duration of the competition. The attendance sheets for 1L students will be at the back there. There's a table set up with the attendance sheets that you can sign in your name for your Lawyering Skills 1 class. There are also programs available back there and pizza available on the side tables. We would ask that you don't get up in the middle of the competition, but eventually when we are in recess, you can feel free to go grab more pizza if you'd like. We would also ask that you silence any phones or electronic devices, anything that makes any noise, so that it doesn't disturb the competition. Today will consist of arguments on the case of Wymann Pharmaceuticals, the People for Alternative Medicines. Seated at this table will be the Appellees representing PAM, or People for Alternative Medicines, Mr. John Young and Santino Cafarella. Seated to my right will be representatives for the Appellant, Wymann Pharmaceuticals, Ms. Megan Anderson and Mr. Noah Woods. After the arguments are heard, the judges will be excused to deliberate and choose the competition winners. Today they will be choosing a team award for either one of the two teams and the Best Oralist award that goes to one individual. Additional information about this case, the competitors, and the judges you are going to hear from today can be found in the paper pamphlets available in the back next to the attendance sheets, as well as on the competition website, which is through the College of Law's website. For this competition, my co-coordinator John Robinson will be keeping time for the competitors, and I will be calling the court to order. With that, we'd like to turn it over to our Dean Barrows to give some opening remarks.
Thank you, Wesley, and thank you all for joining us. It's so great, as Wesley mentioned, to be back in person for this after a couple of years of pandemic virtual competition. My thanks to Wesley and John for all of their work as Fornoff coordinators. This is a really big effort. Thank you. Also to Professor Kristen Beach for her help as faculty coordinator. There is a lot of work that goes into administering these and making these events come together. My thanks to Ryan Overdorf and the rest of the tech team for taking care of our technology needs today. Also, my thanks to the judges for coming in and participating today. And last but not least, I really want to thank Judge Carr for his help in selecting the judges. He does this for us every year, and we're very appreciative to him. So, it's great to see you. Best of luck to all the competitors. I know you're all going to do great. Wesley, let me turn it back over to you.
Thank you. All rise. The judges of the Court of Appeals for the Sixth Circuit of the United States are now in session. Oyez, oyez, oyez. All persons having business before the Honorable Sixth Circuit of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. The Honorable Judges Fleming, Judge Brennan, and Judge Pietrykowski presiding.
Thank you. Please be seated. Welcome all to the finals of the competition. Congratulations to the participants and to everybody who competed in the conference, in the proceedings. I was thinking of conference. Thinking of something else as we were talking before we came in. I feel lucky to be in the middle of two esteemed federal judges today, and we're all been elevated to the Sixth Circuit Court of Appeals, which is nice to be for at least an hour or so. All right, we're going to hear arguments in the case of Wymann Pharmaceuticals versus People for Alternative Medicine. Counsel, are you ready to proceed? And for the appellants, we have Megan Anderson and Noah Woods. For the appellees, John Young and Santino, put these on, Cafarella. A name like Pietrykowski, I think I'd figure out how to pronounce. Okay, thank you. For the appellants, you have 20 minutes. Is it 20 minutes? How much time, if any, would you like for rebuttal, if you need it, rebuttal? 2 minutes for rebuttal, all right. Please begin. The bailiff will notify you as to your time.
Good afternoon, and may it please the court. My name is Megan Anderson, and along with my co-counsel, Noah Woods, I am representing Wymann Pharmaceuticals, the appellant in this matter. Would the court like a brief recitation of the facts?
Please.
In January of 2022, Wymann Pharmaceuticals filed a complaint against the People for Alternative Medicines, who I will refer to as PAM, for copyright infringement. Wymann has established a prima facie case for copyright infringement. They are the owners of a valid copyright for the material in question, and PAM has admitted to copying portions of that copyrighted material in the creation of their advertisements for their product known as Natratab. The pictures of the advertisements are available in the record, with Wymann's advertisements on pages 4 through 7 and PAM's advertisements on pages 8 through 13. In response to our complaint, PAM moved for summary judgment, claiming that their use of Wymann's copyrighted material was a fair use of that material. The District Court for the Eastern District of Michigan granted PAM's motion for summary judgment, holding that there was no genuine dispute of material fact in this case. There are, however, Your Honors, genuine disputes of material fact in this case. When discussing a fair use defense, the court uses the statutorily created four-factor analysis. Today, I will be discussing factor 1, while my co-counsel will address factors 2, 3, and 4. There are genuine disputes of material fact under all four factors in this four-factor analysis. Some of those include the extent to which the clearly commercial nature of PAM's alleged infringing work should weigh against fair use, whether PAM's alleged infringing work is sufficiently transformative to justify its substantial degree of appropriation from Wymann's copyrighted material, whether the amount and substantiality of PAM's copying of protected materials exceeds the bounds of fair use, and whether PAM asserted sufficient evidence to show that no reasonable juror could find in favor of PAM that their Natratab advertisement had an adverse impact on the market for Wymann's original copyrighted work. All four factors of this four-factor analysis weigh in Wymann's favor. However, in order to reverse a grant of summary judgment, we only need to show that there is one genuine dispute of material fact in this case for which a reasonable jury could find in our favor, or that the district court erred in their analysis when balancing this four-factor test. For these reasons, we ask this court to reverse the grant of summary judgment and remand this case back to the lower court. The Supreme Court in Campbell v. Acuff Rose Music stated that when looking at the fair use defense, we should not be bound by bright-line rules. We should instead look at these cases with a case-by-case analysis. This might suggest that summary judgment is not the correct place to deal with a dispute of this type. The Second Circuit, in Roger v. Coons, went further to say, the fact that the test envisioned by the Copyright Act is dependent on the circumstances of each case might suggest that summary judgment is unavailable when fair use is the issue. This circuit, in Zamba Enterprises v. Panorama Records, reminds us that when reviewing a grant of summary judgment, All evidence and all inferences drawn from that evidence should be viewed in the light most favorable to the non-moving party, in this case, Wymann Pharmaceuticals. The record in this case does not weigh overwhelmingly in favor of Pam, nor have they overcome the burden placed on them when using an affirmative defense of fair use. For these reasons, summary judgment should not have been granted by the lower court. The first factor of the four-factor analysis is the purpose and character of the use. This factor is typically broken down into three subparts. First is the purpose of the alleged infringing work commercial or nonprofit. Next, how transformative is the alleged infringing work? And finally, is the alleged infringing work a reasonably perceivable parody? This factor weighs in Wymann's favor because the alleged infringing work in this case is commercial in its purpose, non-transformative, and is not a reasonably perceivable parody.
Let me stop you there, counsel.
Yes.
You talked about the Campbell case.
Yes, sir.
And one of the things the Campbell case talks about is whether or not the new use conveys a new message, right?
Yes.
Now, with regard to Pam's use of your copyrighted material, there's new imagery, right? There's a new catchphrase, right? There's a new, when they say something different with regard to relief, the first one said need relief, and then theirs says need real relief, right? And then all of this relates to an alternative medication, right? Nutritab, or what, I forget the name of it, but as opposed to Clarizac, correct?
Correct.
So why should we find that it's not transformative? It does convey a new message about a new type of alternative to your chemical-based medication.
The test that you cited, correct, was from Campbell, is whether or not the secondary image adds a new meaning or message. As you mentioned, the slogan is slightly changed, and the images, the facial expressions of the images is also slightly changed. But the message in both advertisements is the same. It's unchanged. The advertisement is saying to the consumer, are you suffering from depression? Buy our medicine, it will help. Both are trying to sell a product, meaning they are commercial in nature, and both give off the same message to the consumer. We're here to help you, come buy our product. For that reason, we believe that the secondary alleged infringing work in this case is non-transformative.
Well, but is that the same message? I mean, the first message is use our chemical-based product, right? Okay, the second message is we have an alternative to that you can also use, right? And
yes.
That's I think it's Natratab.
Natratab, yes, sir.
Nutritab
Yes, Your Honor.
I'm sorry.
That's okay.
But so why is that not different? And then I think you understate some of the nuances. I mean, the facial images that are on the new one aren't slightly different. They're different images, right? Correct?
Correct. They are the same type of image, still a headshot image of an actor or an actress. They all use the same color palette. It's the same layout on both of the advertisements with a small text box in the lower left, the name of the product in the lower right, the catchphrase slogan in the upper left-hand corner. They did take a substantial amount of our ad when creating their ad. So even looking at them, it's hard to say that there's a huge transformation between the two of them. And when looking at whether or not the message is the same, although their product might be an alternative on the market, they still chose to place all of their advertisements in the same location that we placed our advertisements, meaning that they were trying to attract the same consumer base that we are trying to attract with our product.
Why does that keep it from being transformative? I mean, and let me finish kind of that question. I mean, if it's an alternative to your product, naturally they want to let people that use your product know that there's an alternative to that product, right? So doesn't it only make sense that it would go towards people who utilize that kind of product?
Correct, Your Honor. That's more speaking to the fourth factor as to whether or not these two products are within the same market and whether or not Pam is trying to supplant Wymann's place in the market for this type of copyrighted material. The transformative message, we believe there is no transformative message here because we are both commercial products. We are both trying to sell our product to a consumer that is suffering from clinical depression. And the Second Circuit in Castle Rock v. Carroll Publishing Group also added that when a secondary use is for the same intrinsic purpose as the copyright owner's use, the claim for fair use is weakened. And since the purpose is intrinsically commercial and trying to sell a product in both of these situations, we believe that that also weighs against a finding of fair use in this case.
You mentioned parity, though, as a factor to consider, right? And
Correct.
you've described these changes, you call them slight, but changes to various points of the advertisement, correct? So when it comes to those changes, these slight changes, as you've called them, isn't that the point of parity? To sort of make those changes slight so people understand the message. And here, wasn't the point of the ad to sort of highlight how pharmaceuticals carry with them all these side effects?
Correct, Your Honor. Opposing counsel is claiming that this is a parody. However, the legal definition of a parody requires the new work to speak directly to the copyrighted work itself. Instead, they have chosen to go after our product, Clarizac, by poking fun at the leading medication in this area, and they've chosen to poke fun at the pharmaceutical industry as a whole, claiming that many advertisements do not honestly put out on their advertisement what the side effects are, and they are not going directly at our copyrighted work. They are going at different parts of it. And Justice Kennedy in his, may I briefly conclude my thoughts?
Yes, please.
Thank you. Because the alleged infringing work in this case is commercial in its purpose, non-transformative, and is not a reasonably perceivable parody, we ask that this court reverse a grant of summary judgment in favor of Pam. Thank you.
Thank you.
Thank you.
Mr. Woods?
Thank you. Is the bench ready to proceed?
Please go ahead.
May it please the court, my name is Noah Woods, and I'm here on behalf of the appellant, Wymann Pharmaceuticals. And as my co-counsel explained, I will be addressing factors 2, 3, and 4 of the fair use analysis to express that this court should reverse summary judgment granted by the lower court in favor of the Appellee, People for Alternative Medicine, who I'll refer to as PAM, because there exists genuine disputes of material fact that are more properly suited for resolution at trial than at resolution at summary judgment. Specifically, I will first address primarily the issue of material fact existing under factor 3 of the analysis, which is whether PAM's substantial appropriation of Wymann's original copyrighted work constitutes an excessive amount beyond the bounds of fair use. Factor 1 is informative under this factor, under the factor 3 analysis, as my co-counsel had alluded to, and as was just being discussed with the bench, the sheer lack of transformative nature of the secondary work here, the NatraTab ads, is informative as to the amount that would be reasonably appropriate for copying from the original work. That's because factor 1 provides a justification, a basis for assessing what is the reasonable amount of appropriation. And as we have in this case at bar, there is an attempt to parody. However, it does not meet the legal categorization of parody as laid out by Campbell and subsequent case law. Specifically in Andy Warhol Foundation for the Visual Arts v. Goldsmith, the court made clear that parody needs to be made to criticize or comment on the original work itself in a reasonably perceivable manner. Here, that is not reasonably perceivable that the NatraTab advertisements are commenting on the copyrighted work itself. These are making more generalized assaults on the pharmaceutical industry, on pharmaceutical marketing, but there's not a direct, clear reference to this is a parody of Wymann's original Clarizac ad. Rather, it could be reasonably construed that this ad could stand on its own 2 feet as a satirical production that is analogous to how the court found in Dr. Seuss v. Penguin Books in the Ninth Circuit. They found that that was beyond the bounds of fair use. Specifically in that case, we had a secondary use, which was a parody of Dr. Seuss's Cat in the Hat. It was intended to mock and comment on the general societal stance around the O.J. Simpson trial. And the court found that because that secondary work failed to comment or criticize upon the Cat in the Hat in itself, Dr. Seuss's narrative prose, but rather it just used that as a free writing mechanism to take a creative, expressive, copyrighted work and enjoy the popularity of that creative, expressive, copyrighted work.
And I understand, Counselor, that with respect to point one, it is the point that carries more weight in this total analysis. But I do want to ask you a question about point two.
Yeah.
The second factor, the nature of the copyrighted work. What do we do about the fact that these ads are so simple? I mean, the slogan is just need relief.
Correct, Your Honor. And factor two actually is informative as well under factor three's analysis, because under factor two, the court has made clear that original creative expressions of work that is the goal of copyright. So factor two looks to give the highest degree of protectability under copyright law to those works that are at the core of copyright. Here, while the ad is merely an ad in some eyes, the court has actually stated, I apologize, the case is not coming to me off the top of my head, but in 1903, the court did state in a case that ads, looking at this very issue, ads are an important, useful work. They have a utilitarian purpose. They inform consumers.
They certainly do, but this ad just simply says need relief. I mean, wouldn't that apply to tax season? Couldn't there be ads during tax season that offer relief, and would that be infringing?
So need relief, as stated in the record on page 18 under the CEO's deposition for Wymann, these ads have become part of the pop culture lexicon. They're pretty synonymous with the idea of need relief is associated with need relief from depression. This is part of a $100 million advertising campaign that Wymann has invested substantial amounts of money to try and stake out this advertisement as something more than just a simple advertisement, as something that has truly transformed Claire's-Act and Wymann's business model. And for that reason, just because it is merely an ad to some does not move it out of the bounds of copyright protection. Turning to that third factor, the amount and substantiality of the copying itself employed in the creation of the secondary work, the nature, as we just spoken on, of that original creative work should afford the highest degree of protection to Wymann under this third factor. Moreover, the fact that it is a satirical secondary work rather than a parodic secondary work gives less deference to the secondary user in appropriating. In Campbell, the court makes clear that the first factor and the third factor are intimately linked. And because of that, this court should find that the genuine dispute that my co-counsel explained under factor one is informative as to a genuine dispute existing under the third factor. Looking at the lower court's opinion here, the lower court admits and acknowledges that the two ads are very similar. However, they give a vague acknowledgement that they differ substantially. They don't list any of these differences, and then they resolve the factor in favor of opposing. That creates a genuine issue, and as this court stated in Wickham v. Knoxville International Energy Exposition, the granting of summary judgment, especially in favor of a defendant, is a practice that should be used sparingly in copyright infringement cases. This conversation in this case out of the Sixth Circuit came under the third factor because, as the court acknowledged, the jury is more properly suited as a type of proxy for what the reasonable juror is, or the reasonable viewer would be, rather than a judge at summary judgment. That was reiterated in Murray Hill Publishing v. 20th Century Fox out of this circuit in 2004, in which the court specifically stated, a jury deciding the issue of substantial similarity not only makes a finding of historical fact, but also serves as the proxy for the work's intended audience. When we turn and look at the fourth factor, that intended audience is a consumer base that is the same. They are individuals who are seeking relief from depression, and because of that, they are looking for advertisements to inform them on ways to get that relief.
Counsel, what was the purpose of these ads?
The purpose of both ads is the same. It's a commercial purpose to sell a product that is promised to give the consumer base relief. And because of that same commercial purpose, this court should find that the commercial nature cuts against, on the fourth factor, a finding of fair use. That Campbell is made clear that commercial nature is not dispositive of a finding against fair use. However, Campbell was also clear to say that commercial nature can still be informative. And when we look at that fourth factor, there is a clear market harm to Wymann's potential to license these secondary, or to license our original works as for a generic use, perhaps for a generic company, the opposing counsel has completely diluted the value of our ad in that sense, in that licensing sense.
Well, let me stop you there. First of all, when you talk about the purpose of the ads, isn't that a little oversimplistic? I mean, you got one ad that, the original ad, which talks about a chemical-based medication, right? And you got a second ad that refers to an alternative to the chemical-based medication, right? Now, there are some people out in the world who are just simply not going to use chemicals, right? They're going to look for an alternative way to get the same relief, right?
Correct.
And arguably, those people are never going to buy your product anyway because it's a chemical-based product, right?
Correct.
So to some extent, there's an argument that to the extent that there's a diminishing of your market, it's really because of people who just simply aren't going to use your product anyway, and now they're aware of the naturopaths, right?
Correct, Your Honor. So if I may answer your question, I see my time has been reached. The potential, the purpose, the commercial purpose of this secondary work, if it was to attract individuals who were not seeking, who would never, as you say, go near a chemical product such as Clarizac, then the opposing PAM could have simply ran an ad contrasting, hey, they could have appropriated much less than was necessary. They did not need to make such a substantial appropriation of this original work, because this is clearly intended, from Wymann's perspective, to pull that consumer base who is already invested into our product and is dissatisfied.
Let me interject another thought for you. The fact that you say this has diluted your market or what have you, could that not be also based on the fact that they've now become aware, based on this issue, you call it satire, others call it parody, but because now they're aware of these nuances to your product by way of side effects. And so now, if there is some deterioration to your market, it could be because they've now been made aware of these side effects, correct?
So while the court was clear in saying that market suppression from biting criticism is not protectable under copyright and is not cognizable under the fourth factor, the market harm we are suggesting here is a market harm to the copyrighted work itself, which is truly what is at issue under factor 4, and that is the copyrighted work, the Natrotab or the Clarizac ad itself, and our Wymann's ability to license such ad. And by taking that ability away from Wymann to do so, you're entirely correct. Wymann should have had the option to license its ad to a generic, natural, homeopathic competitor as a way of making this type of satirical ad so that they could promote their own product. However, that was taken from us, and that undermines fair use. And for that reason, we request that this court reverse summary judgment and allow this to proceed for further hearing.
Thank you.
Thank you.
Thank you. For the appellees, we'll have Mr. Young, you're arguing first.
Yes, Your Honor. Is the bench ready to proceed?
Yes, please. Go ahead.
Thank you, Your Honor. And may it please the court, my name is John Young, and I, alongside co-counsel Santino Cafarella, represent People for Alternative Medicines, which I will refer to as PAM. PAM is before this court today as a result of a copyright infringement claim to which PAM has asserted a fair use defense. The Eastern District of Michigan properly granted PAM's motion for summary judgment, and PAM is before this court today to ask that that grant of summary judgment be affirmed. As enshrined in Article 1 of the Constitution, copyright law is intended to promote science and the useful arts. And as articulated by the Supreme Court in Campbell versus Acuff Rose Music, fair use serves that very purpose. And for that reason, as declared by the Supreme Court in Stewart versus Abend, courts are permitted and in fact required to avoid rigid application of copyright law when it would stifle the very creativity it is intended to foster. And parody especially has a special place in the fair use analysis, where as articulated by the Second Circuit in Leibovitz versus Paramount Pictures, parody is deserving of fair use protection because it is extraordinarily unlikely that the creator of an original work will license a secondary work to which will subject their work to negative criticism.
Your opposing counsel has referred to your, the second use or the use by Pam of aspects of their ad as satirical as opposed to parodic. What's your response to that?
The case law points in the opposite direction, that this is a parody. And to use the same case, Dr. Seuss versus Penguin Books out of the Ninth Circuit, the Dr. Seuss case, the book Cat Not in the Hat, used as a commentary on the O.J. Simpson murder trial, simply used the copyrighted material as a vehicle to comment and criticize something totally unrelated. Whereas the current advertisements, the Pam works, are commenting directly back on the copyrighted material, commenting on and criticizing the fantasy that is being sold to consumers in those advertisements. The idea that Wyman's product is the so-called silver bullet. You will be happy, like the people that are visible on pages 4 through 7 of the record with the Wyman advertisements, whereas the Pam advertisements are calling the public's attention to what is not being portrayed in the Wyman advertisements by exaggerating the side effects, calling attention to those side effects, and therefore criticizing the works, which is why the current matter is readily distinguishable from the Penguin Books case.
But we're here on de novo review because the district court granted summary judgment in your client's favor. So even if it is a parody, the fact that Pam decided to marry up a commercial purpose with these advertisements and market a separate product, doesn't that undisputed fact prevent the district court from summarily dismissing the copyright claim? Didn't the district court actually just get it wrong?
The district court did not get it wrong, Your Honor, and that is because under the first factor analysis and the purpose and character of the use, commerciality is not dispositive, as discussed by the Second Circuit in Leibovitz versus Paramount Pictures. Additionally, as discussed by the Supreme Court in Campbell, the more transformative a work is, the less any commerciality looms in the analysis. And because the case law and the facts at hand are able to establish a parodic work that is highly transformative, the commercial nature of these advertisements is given reduced weight. And in a very similar set of facts to the Leibovitz versus Paramount Pictures case, where in Leibovitz it was the Demi Moore picture that was on the cover of Vogue that was parodized by Paramount Pictures with Leslie Nielsen to promote a movie, that the finding of parody and the transformative nature tipped the first factor in favor of the parodist, regardless of the totally commercial nature of that work. And that's not to say to even distinguish Leibovitz from the present case, where the Leibovitz case was purely, on its face, a commercial advertisement that was found to be a fair use. And additionally, the Leibovitz, the Paramount Pictures work in Leibovitz didn't have any sort of additional purpose that the Pam ads do, which is being educational as well, educating the public about what is being hidden from them in those advertisements. And that educational mission of Pam that is evident on the 24th page of the record in the Pam CEO's deposition. So because following Leibovitz in that analysis, the commerciality is not dispositive and has very little weight in the first factor.
Let me ask you this, let me interrupt you for a second, because if the primary purpose is to engage in parody, or if it's to have an educational component, as you state, why did there have to be a commercial product marketed at the same time?
Well, certainly, in part of proposing an alternative and calling attention to the what is being hidden from the public is to propose that there is some sort of alternative. Pam would contend that what good would this criticism be if there's no idea of an alternative? If homeopathic medicines, natural remedies, certainly, and as co-counsel will discuss, serve a different market, in a market that caters to two different groups of people. And because of that, sort of the mainstream users may need attention called to that an alternative really does exist. And under the first factor analysis, a parody, as discussed by the Supreme Court in Campbell versus Acuff Rose Music, is a work that comments or criticizes the original. And as discussed earlier, the Pam works do directly comment and criticize on the fantasy being sold in the original. Additionally, in Leibovitz, when discussing the reasonable perception of parity that the Supreme Court articulated, the Second Circuit found that the striking contrast in the facial expressions between the Demi Moore picture and the Leslie Nielsen advertisement achieved the effect of ridicule and allowed for the parody to be reasonably perceived. And as Your Honor pointed out earlier, there is certainly a striking contrast in these images evidenced in the record between pages 4 through 13. Additionally, in regards to summary judgment, to which opposing counsel has discussed, opposing counsel cited two separate cases to suggest that summary judgment is not appropriate. However, the case law within the Sixth Circuit points to the contrary. First, in Zamba Enterprises versus Panamera Records from the Sixth Circuit, summary judgment was used as the appropriate remedy in that case. Additionally, opposing counsel cited Murray Hill Publishing versus 21st Century Fox out of the Sixth Circuit and quoted material to suggest that summary judgment should be used sparingly in copyright infringement cases. However, the very next sentence of the Murray Hill case says, and I quote, "Summary judgment is still permissible and may even be required," end quote. Additionally, in that case, the Sixth Circuit remanded the case, the Murray Hill case, back to the district court for entry of judgment as a matter of law in favor of the defendant. Additionally, there has been, and we have spent much time analogizing the facts of this case to Leibovitz versus Paramount Pictures. And further, in Leibovitz versus Paramount Pictures, the Second Circuit did affirm summary judgment in favor of the defendants. Additionally, the Eastern District of Michigan, where this case originated, in Gordon versus Nextel Communications, also used summary judgment as the appropriate remedy. And because summary judgment is the appropriate remedy in this case, and the case law points to that direction, Pam asked that the lower court's grant of summary judgment be affirmed. And that is, yes, Your Honor.
Go ahead.
And that is because of the highly parodic and transformative nature of the work. Additionally, speaking towards the transformative nature of the work, as discussed, opposing counsel discussed the Castle Rock case. In Castle Rock, the court articulated that a work is transformative when it takes the original, the copyrighted material, as the raw material to create something new, to add new insights, new expression, and new meaning. And that is present in this case, as the Pam advertisements certainly add.
Well, counsel, why shouldn't we just say, look, Wyman's trying to sell a product that deals with depression. You're trying to sell a product that deals with depression. You used Wyman to get market share. You used portions of their advertisement to get a part of the market share. It's really just commercial. This is just you seeking to gain some commercial advantage. Why shouldn't we just say that? Especially in light of the fact that we have to look at the evidence in the light most favorable to Wyman.
Yes, Your Honor, and co-counsel will further develop the fourth factor, the effect on the market for the original, which indicates that the market effects to which opposing counsel is called to are not what the court is looking towards in this analysis. But additionally, as discussed earlier from the holdings in Campbell and Leibovitz, because this work is highly transformative and parodic, Your Honor, may I have a moment to conclude?
Sure.
Because this is highly transformative and parodic, the commercial nature is diminished in the analysis, and similar to the highly commercial nature in Leibovitz that did not weigh the first factor against the parodist, that is what Pam asked this court to do as well, following the case law. And for that reason, and because summary judgment is shown to be the proper remedy within this circuit, Pam asks that this court affirm the lower court's grant of summary judgment. Thank you.
Mr. Cafarella.
Is the court ready to proceed?
Please, go ahead.
May it please the court, I am Santino Cafarella. I represent the Appellee People for Alternative Medicine, also known as PAM. As co-counsel John Young addressed Factor 1 and its respective subfactors, I will address Factor 2, the nature of the copyrighted work, Factor 3, the amount and substantiality of the portion used, as Pam's advertisement which is a parody, merely used what was necessary to conjure up the image of a parody. And factor 4, which is the effect of the use upon a potential market, which weighs in favor of Pam, as Pam's parody, which criticized Wyman's advertisement, suppressed the demand of the product rather than be a market substitute. Directing the court over to factor 4, the ruling in Campbell v. Acuff Rose, the Supreme Court case, in the Justice Souter's factor 4 analysis is analogous to our case, as in Justice Souter stated that there is no protectable derivative market for criticism, as a company will not license its product out for criticism generally. This applies here, as Wyman would not license the product out for a potential criticism, as Wyman's product displays misleading images of a false narrative, and Pam's criticism brought this to the forefront. Campbell also stated that in regards to criticism, that while a parody may not harm the market at all, when a lethal parody kills demand for the original, it does not produce a harm cognizable under the Copyright Act, because a parody may quite legitimately destroy the original, destroying its commerciality as well as artistically. This is present here as Pam criticized the false narratives of the fantasy that Wyman attempted to sell to the consumer through their misleading advertisements, which Pam brought forward and ultimately showed in their advertisements.
Counsel, let me interrupt you. I understand why you would, in your position, want to rely heavily on parody. But this isn't just a situation of parody. There was a marketing of a competing product. Doesn't that create issues?
Yes, Your Honor. It doesn't create an issue because commerciality is not dispositive in the when balancing this factor.
It's not dispositive, truly. But it is something that should, in this instance, because we're on de novo review and it's summary judgment, it should weigh in Wyman's favor, though, should it not?
Just to reiterate, Your Honor, you're asking about the commerciality aspect weighing in favor of Wyman, correct?
Yes.
Yes, that would weigh slightly against Pam, though the other factors will make up for that, as in a case that dealt with work in a similar market. For instance, the Max Tone Graham case out of the Second Circuit, it dealt with a book that was written in pro-choice in 1973. About a decade later, a priest wrote a book in favor of pro-life, and it was about abortion. They're both books, and the priest used substantial amounts of the original book, sold it, but the court ruled that because it served a different market, it did not weigh against fair use. Looking back to the case law that demonstrates the ability for the suppression of a product through criticism, in the 11th Circuit, the SunTrust Bank case dealt with the 1936 novel Gone with the Wind, which was lampooned in a 2001 novel, and it ultimately criticized the original work heavily, and it used substantial portions of the original book, though the court stated that suppressing the demand through criticism should not weigh against fair use. This sentiment is also shared in the 9th Circuit in the Fisher versus Dees case, which dealt with a parodist parodying the original song When Sonny Gets the Blues, and in his parody he significantly criticized the original work, and that court held that biting criticism, suppressing demand does not preclude fair use, which is precisely the case here, as Pam ultimately, Pam's criticism of Wyman's product is what caused the suppression of the demand, rather than it being a market substitution in place of its advertisement. Directing the court over to Factor 3. Factor 3 weighs in favor of Pam, as Pam's parody of Wyman's Clares Act took merely what was necessary to conjure up the image of a parody and nothing more. Looking at Campbell once again, Campbell stated in this regard that when a parody takes aim at original work, the parody must be able to conjure up at least enough of the original to make the object of its critical wit recognizable. A parodist may take the most distinctive or memorable features which the parodist can be sure the audience will know. In this-
Counselor, can I stop you there for 1 second too?
Yes, Your
When
Honor.
I compared the ads, it looks like, in fact, more than what was necessary was used. I mean, virtually every component of Wymann's ad was altered in a way that to meet, Pam's purpose, right? So the background, people giving expressions, where the advertisement was placed. I mean, wasn't it really just a sum total of putting alternate content in a manner that was quite married up to Wymann's advertisement?
Not necessarily, Your Honor, because when you look at the advertisement as a whole, you see, for instance, the text placement on the advertisement is in similar places, but that's an industry norm rather than a copyrightable element. But when you look at the copyrightable elements, such as the picture, like there was a different actor in place, there was distinctly different facial expressions, there was different text in those the text placements.
But how about the slogan?
The slogan. The slight modification to the slogan would be enough to change the meaning of it, as ultimately that's what one looks for in the third factor, is the changing of the meaning. And precisely Pam stating need real relief is different than need relief, Your Honor.
Well, let me ask you this question, counsel, and this kind of piggybacks on that. I mean, Wymann's ad was well-known nationwide, correct?
Correct, Your Honor.
Okay. And so doesn't that militate in favor of the fact that you need to use less of it to make your point? Because people are going to see it and they're going to see certain elements of it and they're immediately going to attribute that to what was in Wymann's original ad. Whereas with your ad, I mean, there may be nuances to each element, like in your slogan, instead of need relief, it needs real relief. There may be nuances to the faces in that they don't have the same expressions, but you still got faces. There may be nuances to the text, even though there's still a text aspect to it. So at the end of the day, there's the argument that given the nationwide character of Wymann's ad, you didn't need to use that much in your ad. Isn't that an argument?
Yes, Your Honor, it could be, but as previously stated, Pam's advertisement did transform the original work substantially with the distinctly different exaggerated facial expressions, different background coloring and such, which would distinguish the two. Which brings me to a case that's analogous to this, out of the Northern District of Illinois, the Eveready v. Coors case. In that case, it dealt with the Energizer Rabbit being placed in the Coors Light commercial. And in this commercial, Coors Light transformed the image of the Energizer Rabbit substantially, but it was enough for one to recognize it was still the Energizer Rabbit that they're referring to. The court ultimately stated that they deemed this a fair use as the dissimilarities were more prominent than the similarities in the advertisement, and the differences coupled with the few identifiable features were enough for the court to make this conclusion. The court also held that when looking to conjure up, one must not look at conjuring up as a limitation, but rather that a recognition that a parody frequently needs more than a fleeting recollection of the original in order to make its humor point, which is precisely the case with Pam, as Pam needed to use enough in order to get the humor point across that the Wymann advertisement portrays these individuals who take their drugs as very happy with no issues, and Pam wants to show that these side effects are very prominent in their medication. Looking over to factor 2, as opposing counsel mentioned, that these advertisements serve a utilitarian function, which is what Pam would agree with, as in the Google v. Oracle case, 2021 Supreme Court decision. It stated that when dealing with a work that has a utilitarian function rather than an artistic function, one is able to take more of the original as it serves a practical function rather than a creative function, and it allows for one to use more as it's not as original. And ultimately, that's why factor 2 would also weigh in favor of Pam. Though this is precisely the reason why, when weighing all 4 factors together, this is precisely the reason why the 1976 Copyright Act is codified, as it promotes the furtherance of, may I have a moment to complete my thought? Thank you. As it furthers the arts and sciences, and it ultimately the goal of these advertisements is to inform the American consumer of the negative nature of the Wymann product, and ultimately lead them to make better decisions, which is why Pam respectfully asks the court to affirm summary judgment in favor, affirm the lower court's summary judgment. Thank you.
Thank you, counsel. Rebuttal for the appellants. Mr. Woods.
Thank you. Is the bench ready to proceed?
Please proceed.
There are genuine disputes existing as to the lower court's determination under Factor 1, and opposing counsel is completely wrong in claiming that the parodic nature is clear and warrants diminishing of the commercial purpose of the secondary works in the case at bar. The parodic nature needs to be reasonably perceptible, as laid out in Andy Warhol Foundation for the Visual Arts v. Goldsmith. Here, that is not a reasonably perceptible, that is up to genuine dispute. It should be taken to a jury to determine if the lay observer can look at the secondary work, in this case the NatraTab ads, and determine that that ad cannot stand on its own 2 feet, as Campbell has described satire as being. Because both works serve that same primarily commercial purpose of marketing competing products, that has a significant impact on the subsequent analysis that the court's determination that ultimately concluded was fair use. Because the first factor is the soul of the fair use analysis, according to Judge Pierre Laval, who was cited in Campbell, this court should find that the existence of this clear dispute of material fact should warrant remanding and allowing this to proceed to jury trial. Furthermore, opposing places significant reliance on Leibowitz. Leibowitz does not binding precedent on this circuit, and moreover is clearly distinguishable from the case at bar. In Leibowitz, the author and the copyright holder themselves admitted that there was no clear market harm presented by the secondary work. Moreover, the image of a naked woman that is pregnant posing with her hand on her hip has been in the public domain since Botticelli. Lastly, the faces in that case, while they were different, and that difference in expression was sufficient for fair use. In the case here at bar, that there's the similar message. In Leibowitz, there was a complete different message. One was advertising a parodic movie, and the other one was taking a iconic image. I see my time is concluded. May I finish?
Please finish.
The distinguishing factors between these two cases do not warrant this court completely going against the precedent laid out in Wickham v. Knoxville, and this court should allow this case to be remanded for further proceedings after reversing summary judgment. Thank you.
Thank you, counsel. Yeah, sure.
All rise. For the court is now in recess. All rise. The court has made a decision.
Please be seated. In case of Wymann Pharmaceuticals versus People for Alternative Medicines, the court rules in favor of Wymann Pharmaceuticals. Congratulations. Now the next decision is for the oralist, and obviously this was a very difficult decision, not that it was, because it was, everyone did such a tremendous job, and we were required to pick a winner. You know, I think we'd agree that you're all winners. Congratulations. We choose for the oralist, Megan Anderson. Congratulations. And I'll turn it over to my colleagues right now for comments if they'd like to start.
You essentially picked the team.
We picked the winning team.
Okay.
This-
Right. I was like, was that the merits or
I
was
mean-
that the team? Got it.
Well,
Understood.
I guess it could have gone, oh, no.
No, I mean, I said back there that if you guys represent the future of our profession, we're in very, very good shape. You really did a wonderful job.
You all did a fantastic job. The last thing I felt comfortable doing was going somewhere and deliberating anything. That's how good a job you all did. Let me say something to you. You were the second person on that. I just don't have your name in front of you, but you were the second person for the PAM team. I loved what you did when you had a moment where you were at an impasse with your thoughts. Instead of letting that moment turn into a pregnant pause that festers, you stopped it and said, "Can you give me just a minute?" It takes a lot of intestinal fortitude to ask, because you're effectively saying to the court, I need a moment to gather my thoughts, right? And that's not easy to do, especially when you got a gallery of people looking at you, the court is looking at you, everybody's expecting you to say something, but it's the wise thing to do, because it's better to do that, right, than to sit there and just have that pause. Because nothing worse than that pregnant pause and everybody's sitting there waiting for you like, well, what are you gonna say, you know, right? When you put everybody at ease, when you say, can I have just a moment, please? Everybody expects there to be a pregnant pause. Now it's okay, right? So fantastic. Listen, I don't have much in the way of critiquing at all. I think you all did a fantastic job. I echo what my colleagues said. If you four are the future of this profession, we got a real bright future ahead of us. You keep doing what you're doing. Okay.
Thank you. As I said before, I think you're all winners. You did a great job. You probably are more prepared for this case, this issue, than you may ever be prepared again for an issue. Obviously, this is a practice, and it's good practice for the future, how to address an appellate issue or any issue in front of a court, thoroughly have the cases and the facts reviewed and present it that way. But you'll find when you get out into practice, you've got other things tugging at you. And there are only 24 hours in a day, and you have to sleep a couple hours sometimes. But it's a wonderful experience for you. I think you've argued as well as any attorney, probably better than most attorneys I see in our court. And obviously they've got full practice, and there's other issues that come up. But this was a very interesting issue. I'm a state court judge. We don't get copyright cases. I've never seen one that I can recall. So it was very interesting for me to look at this and brought to mind some Weird Al parodies of music as I was reading this. Maybe I'm a little older than, but anything else?
I would just say it was really motivating watching you all, engage in your craft. And I was listening to all of you do your thing, and I felt this need to I need to go back to my chambers and talk to some of the attorneys I have litigating in front of me and say, see, that's how you need to be prepared, like that, right there. Okay? I mean, that's just how good you all were.
And I think it's also, we should thank the staff and everyone who's put this together for us, and also help prepare you to be in the position you're in, and all the competitors. We only got to see 4. I'm sure there were many others who gained a lot from the experience of this, and certainly this is experience you take forward into your careers. And I agree. I'm retiring at the end of January, but I'm looking forward to reading or seeing more about you all in the future, because I'm sure you'll be making good law and doing good representation of clients. Anything else?
No, thank you very much, everyone.
All right. Is that, do we, yeah, I was going to say if.
Today.
We are very proud of all 4 of our contestants here today. They've all done a phenomenal job. Having watched them do this over the past 2 months, I think they absolutely crushed it. And for one final time, I would ask you all to rise as the judges exit, for the competition is concluded. Thank you for being here today.